something that it can't regulate. That's a Supreme Court case, 1922. All right, so the important thing to remember is this is really about the Commerce Clause. And I will mention one judge who didn't completely agree with that, but it is about the Commerce Clause. 21 cases filed, at least last time I checked, challenging Obamacare. There are 3 big cases that you need to worry about or be aware of. There was the Sixth Circuit Court of Appeals. Now, you know the way the court system works. You know, you just Supreme Court and the Court of Appeals. In the Sixth Circuit, 11th Circuit, 4th Circuit, and by the way, North Carolina declined to join any of the lawsuits. So you can thank Roy Cooper for that. Okay, let me take the different circuit court cases one by one. All right, so the Sixth Circuit case was these are all, okay, you had a 3-judge panel, and in 2-1 decision, it basically upheld, it said that Obamacare was constitutional. And it's important to kind of, I'm going to read this, if it takes a little while. It's important to kind of see what they're arguing. The unavoidable need for health care, coupled with the obligation to provide treatment, make it virtually certain that all individuals will require and receive health care at some point. Thus, although there is no firm constitutional bar that prohibits Congress from placing regulations on what can be described as inactivity, even if there were, it would not impact this case due to the unique aspects of health care that make all individuals active in this market. All right, so basically the court's saying Congress can regulate activities that have not yet occurred because individuals likely will engage in the activities. That's what that's what we're saying. What we've got here is because it's virtually starting, people are going to need it at some point. And we also talk about the obligation to provide treatment. So in other words, because we've decided as Congress, we've decided as a country to make sure that people who go to the emergency room get treatment. Therefore, that obligation that Congress has created, therefore somehow gives them power under the Commerce Clause, or its justification under the Commerce Clause to show that they can regulate health insurance or something along those lines. It's just silly argument. So we're going to regulate activities that haven't occurred because you're likely to actually engage in an activity. Well, you're likely to buy a car at some point in your life. Can Congress force you to buy a car? You're likely to, unfortunately, need a lawyer. Can Congress force you to hire a lawyer? Receive an education? Can Congress force you to go to a private institution, college, university? I mean, the idea that something is likely to happen, or you're likely to use it, we can make the case for that for almost everything. And you say, well, more people are going to need health care as opposed to absolutely drive. So what are we going to do? Set up percentages? Well, 92% of the population is going to need health insurance or health care at some point, whereas only 86% are going to drive a car. I mean, there's just an artificial, you can't distinguish between that. They're just making things up. These are my arguments, not the court. Okay. When Congress regulates something, we have to focus on an activity. Once again, get back to the activity. And that's when we focus on an activity, we're talking about a tangible indication that something has actually occurred. If somebody grows wheat, we know that somebody has grown wheat. We're not thinking about, well, is that person likely to grow wheat? We're not thinking, is that person, and in previous cases, in the lower court, they're talking about, well, it's not about activities, it's about decision making. Well, did the person, were they thinking about, potentially growing wheat? Well, we can't be mind readers. Government may think they are, but we can't. And the government always can regulate activities once they've taken place. So why can't Congress simply regulate or health care decisions at the time that they occur? You regulate the activity, not something that hasn't occurred yet. And an important point is they keep talking about this being need for health care. This isn't about health care. This is about health insurance. Okay, this isn't, yeah, you might need health care. You may need to go to the hospital, and maybe if you don't have health insurance, government might have to pay for some of the costs. But that's health care. That's not the health insurance. It's different. Health insurance is a market. You can go your entire life without ever owning health insurance. That doesn't mean that, in fact, it's a decent chance a lot of people aren't going to have health insurance in their life. In fact, proponents of this bill, that's their concern. They're upset because too many people don't have health insurance. So you can't make the claim that a lot of people are definitely going to have health insurance in their lifetime. Most people will, but so it's important to remember that distinction between health care versus health insurance. The mandate isn't you must enjoy or the benefits of health care or buy health care. It's you need to buy health insurance. In fact, it's not even you have to go to the doctor to get a checkup. I can go to the doctor, get a checkup, pay whatever I have to pay. It doesn't mean I have health insurance. It's a different product. All right, now getting into some more common sense. 11th Circuit, another 2-1 decision. This is the Florida case. Okay, this is the Florida case with the 26 states that joined together. Not North Carolina. And I'm just going to read it, and you can kind of hear them echoing what I have said. And I'm not saying they're just listening to me. I don't know. Maybe they saw my presentation and copied me. I'm that influential. The government's position amounts to an argument that the mere fact of an individual's existence substantially affects interstate commerce, and therefore Congress may regulate them at every point of their life. This theory affords no limiting principles in which to define Congress's enumerated powers. And what they're saying is exactly what I was saying. So there's no way, how do we know as a court to know, okay, so Congress can mandate health insurance, but why can't Congress mandate gym membership? Or this other. There's no way to clearly define where the limits are of Congress's power. Continuing on this quote, the federal government's assertion of power under the Commerce Clause to issue an economic mandate for Americans to purchase insurance from a private company for the entire duration of their lives is unprecedented, lacks cognizable limits, and imperils our federalist structure. It certainly is unprecedented. And certainly invades our liberty. One argument I made in an op-ed was there's a lot of focus on the fact that Congress can force you to buy whatever they want you to buy. But let me give you another example that I actually don't think anybody else has argued, and I take it as my original argument. I take credit for it. What limits Congress from forcing you to just not only to buy whatever they want you to buy, but just, I want you to buy health insurance. I want you to buy gym membership. They list 20 things. You'd have they could create a situation where you have so many mandates, you have no ability to use any discretionary income for yourself to buy anything on your own. They could literally tell you every single thing you have to buy and leave you no way to buy your own types of purchases. They could control your life as a result. Heck, they could force you into bankruptcy if they wanted, if we because there's no limit to it. All right, so there's the Fourth Circuit.
Can I throw out one there?
Yeah, go ahead. Sure.
If they can do that on the wheat clause, then they can tell you what you can raise in your garden. Because what you raise in your garden, you will not be able to go and buy on the open market. They have no right under the Constitution to force me to do something, unless I wanted to give them that right. We have given our rights away to a bunch of idiots. just to be frank about it, and it's time we stood up and said, enough is enough. And advise them that if you vote again for anything like that, say goodbye. And I've often, sir?
Well said. I agree. Yeah, they could tell you to buy, well, I don't know if they would necessarily say grow something. I mean, we would want to keep it somewhat in a kind of a commercial type of transaction. You have to buy, I don't know, certain types of flowers that you can grow in your garden. I don't have much of a green thumb, so I don't know. But they could dictate exactly what types of things you could grow in the garden. Or the types of things you could buy that you would use in the garden. And then you'd have to do that. But worse is they could say, even more so, is that if you're not growing something in your garden, you do have to buy something in order to grow something in your garden. So it's worse than simply, I'm somebody who likes to grow things in my garden, and they're going to dictate what types of things. It's worse. I could be the person who doesn't like to grow anything and doesn't want to grow anything, but they're going to force me to grow something in my garden. So it's even worse. Fourth Circuit, North Carolina, as you know, is in the Fourth Circuit. And the Fourth Circuit recently heard 2 cases. And one of the cases is this case is the Virginia case. Okay? And what you probably may have heard, or may not have heard, quite honestly, was some sloppy reporting. And I'm not picking on liberal media, or because I saw it both. Sometimes legal reporting is not really very good because the reporters aren't really lawyers who don't really know anything about the law. The court didn't reject any challenges to Obamacare in the Fourth Circuit. The Fourth Circuit didn't rule on what's called the merits of the case. It didn't decide whether or not Obamacare is constitutional. What it did was it said that there was no standing, you know what standing is, in a case, and therefore, as a result, the court couldn't hear the case. So it was on procedural grounds, the court decided not to hear the case. And just so you know what standing means, hopefully it's not insulting you, but standing, you have to have suffered an injury, in fact, in order to actually bring a case. So if, just because something, if that pizza parlor right there poisons that person right there at the counter, and I somehow am just upset about the fact that they poisoned that person, not intentionally, but they got the person sick, I can't really sue the pizza place, most likely, because I haven't suffered an injury. But the bad person could sue the pizza place. So you have to be the one that suffered the injury. So they were arguing that Virginia didn't really have standing in the case and didn't suffer the injury. There are other procedural issues as well in the case. But it's important to know that really only 2 circuits, the 11th Circuit and the 6th Circuit, have actually ruled whether or not Obamacare, and in particular the individual mandate, is constitutional. Not the 4th Circuit. Now, Judge Wynn, you may remember, is from North Carolina. Served on the North Carolina Supreme Court. Only judge, federal judge, to kind of hear this case, hear the challenges to Obamacare, to actually buy the tax argument. And I've already told you the whole issue about penalty versus tax. And honestly, I wouldn't worry about that. His ruling on that. This case is not going to be decided on whether or not it's a penalty or a tax. It's a penalty. The issue is going to be about whether or not it's a Commerce Clause, whether or not Congress has the power under the Commerce Clause. The bill itself makes it absolutely clear that it's a penalty. Now, what you'll start hearing, by the way, is when the Obama administration, the Democratic leadership would try to push Obamacare, they would be talking about it as a penalty, because you don't want to call it a tax, right? Now you'll start hearing them talk about it as a tax. Because once you start hearing it talking as a tax, then it makes it more likely that Congress has the power. If it's a tax, it's more likely Congress has power, because under the tax power, Congress can impose taxes. So I still wouldn't worry about that.
Which will shoot them in the foot, because nobody likes to hear about an additional tax. So they're kind of between a rock and a hard place.
There are some Democratic consultants, and certain consultants have been like, no, what should we do?
Let's create a flowery word for tax.
I think we'll come up with something. What's that about?
Don't you think that that's what's going to happen in the Supreme Court? That's what they're going to fight against. They're going to bring that up as far as the tax goes. That the Constitution tells us that the Congress has the right to taxes and spending.
Oh, there's no question.
And look out for the welfare of the people and that sort of thing. So it's going to come about that, and that's what the whole thing's going to be fought on.
I don't think it's just going to fall on the Congress.
What's that?
It won't fall on that. The federal government will make that argument. Certainly, the federal government will argue that Congress has tax power. They'll make that argument. They have throughout all the challenges. They just won't win, is what I'm saying. It doesn't mean that some judges won't buy it, but, sorry, go ahead.
Going back to the Virginia law, I don't know all the ramifications of it, but they said they didn't have standing, but if they, like the rest of us, are under the mandate, why would they not have standing as far as that? Or I don't know why they ruled it out that they didn't have standing, but...
There's a couple of things going on procedurally. But you're right. I think a lot of it had to do with the timing of when the penalty were imposed. Had something to do with it. But actually, that made it not what's called not ripe. The standing issue, oh gosh, if I can remember. What's interesting about the Virginia case is that Virginia, as far as I know, is the only state to have passed a law saying that they're not going to require health insurance imposed on their citizens. So why did Virginia pass that law before Obamacare passed? Because to make it even more likely that they would have standing, but it still got struck down. And I wish I could tell you right now what the reasoning was. Again, I would argue I don't think you're going to see a standing problem here. Because some of the issues that might exist in the Virginia case don't exist in the other cases. Just one other point, I'm not sure if I'm bringing it up later or not. In the district court in Florida, the judge ruled that the entire Obamacare bill was unconstitutional. He struck down the individual mandate, and then as a result, said that because of that, the whole law crumbles and falls, and it's unconstitutional. The 11th Circuit, the higher court, said the individual mandate's unconstitutional, but we can sever, in other words, take out that provision, and the remainder of the law is constitutional. So it is possible that the individual mandate would be found unconstitutional, but Obamacare could still exist, you just won't have the individual mandate. And how that works practically, I don't know, and I don't even know if it can work without the individual mandate. So that would be another issue that you'll probably hear about discussed is, okay, if there's an individual mandate struck down, it's severable. You'll hear that brought up. So, U.S. Supreme Court. So what's going to happen? The court is likely to hear the case this term. Okay, so they're likely to hear the case this term. The Obama administration didn't appeal the 11th Circuit decision. It has actually asked, the Department of Justice actually asked the Supreme Court to hear the case. Furthermore, when you have a split in the circuits, when you have circuit courts disagreeing with each other, the U.S. Supreme Court's more likely to hear a case. And of course, it's pretty important issues, so the Supreme Court's likely to hear it. So, the case will get heard by the Supreme Court, almost guaranteed this term. That means that there will be a decision by June 2012. Not that long, so a matter of months. So this is going to be pretty big. I'm not going to sit here and argue that this is a slam dunk on either side. Certainly the individual mandate is a novel question. It will be a close call. This just screams 5-4 decision and what's Justice Kennedy going to do. That's really what it's going to be, is it Justice Kennedy on the right side or the wrong side? I think it'll be very close. And it doesn't, now if it's 5-4 on the wrong side, it doesn't mean the wrong side that wins won't bring up the tax argument. They might bring up the tax argument. But it really is going to come down to, in my opinion, the Commerce Clause. My fear is that the Supreme Court could be too deferential to Congress and not want to strike down a provision. I mean, generally, as a rule, courts try to ensure that, try to defer to Congress and not strike down laws. There's kind of a presumption that something is constitutional. I don't know why. I mean, that's just been the way it's worked. I think it's absurd that courts have presumed that laws are constitutional. I think it should just be analyzed. The law, is it constitutional or is it not constitutional? When you start with the presumption of constitutionality, you've already created a burden on somebody challenging the constitutionality of the law. So that's certainly a fear. And then, look, the Supreme Court's going to rule. So some of this is, you got the political arena. We know that Congress, this is going to happen. Congress is not going to repeal the bill at this point, certainly. They're going to wait until the Supreme Court does something. Let's say the Supreme Court says it's constitutional. Assuming that, I mean, if Obama won re-election, then we're just going to have to deal with the Obamacare bill. If he's booted out of office, then who knows? Maybe Congress could be able to get rid of the bill. There's other ways to try to weaken Obamacare if it was non-constitutional. You just, through the spending powers that Congress has, you don't fund certain provisions. You know, one of the weaknesses is that if this bill is found constitutional, the implications are, I mean, huge. And it would be, I think, even more difficult for opponents of Obamacare to try to get rid of it. I think it would, you know, the public would be like, the Supreme Court has said it's constitutional. Now you're trying to repeal law. You've been arguing this whole time that it's constitutional. Now you're going to try to repeal it. I think it just puts more pressure on them.